I decided, ladies and gentlemen, to look at what is a crucially consequential decision, if it's not reversed, in Texas involving those 10 seats that Governor Abbott and the legislature created, and the attack by this three-judge panel, the appellate panel, 2 judges voting that it was unconstitutional, 1 judge in an incredible dissent, over 100 pages long, absolutely rejected it. And I want to read you what our friend Hans von Spakovsky had to say about it. He's a great guy at the Heritage Foundation, a longtime friend, and years ago he worked in the Civil Rights Division handling voting rights cases. He said on Tuesday the media was filled with stories that a 3-judge panel had voted 2-1 to issue a 160-page order blocking the Texas legislature's new congressional redistricting plan. The order claimed the redistricting was unlawfully based on race, as opposed to partisanship, a claim at odds with what we saw happen in the partisan political fight within the state legislature, which included a walkout by Democratic legislators. What wasn't attached to the order was the dissenting opinion by Fifth Circuit Court of Appeals Judge Jerry Smith. Now, this man is a 37-year veteran of the federal judiciary, greatly respected for his legal acumen. In other words, he's a towering scholar, incredibly smart. He's an originalist. He sticks to the Constitution. He had a 104-page dissent. It came out a day later. It marks the most scathing denunciation, writes Hans, that I've ever read of another judge. Now, why would a dissent come out a day later? You're about to find out. In this case, the judge being denounced is Judge Jeffrey Vincent Brown. Brown, who wrote the majority decision along with Judge David Guaderrama, who joined the opinion. In his dissent, Smith accused Brown and Guatemala of, quote, pernicious judicial misbehavior, unquote, in deliberately not providing Judge Smith with, quote, any reasonable opportunity to review Brown's opinion and respond before it was issued. I've never heard of this before. So these two collaborated to circumvent the third judge, because they didn't want that judge to have the time to reply to the majority opinion. They were going to just ram it through. I have never, ever, in all the years I've been practicing law, ever seen anything like this. Judge Smith calls it the most outrageous conduct by a judge, and he's talking about this Judge Jeffrey Vincent Brown, the most outrageous behavior by a judge that I've ever encountered in a case in which I've been involved. Now, he's been on there 40 years almost. He spends 4 pages going through the timing involved and says that any pretense of judicial restraint, good faith, or trust by these 2 judges is gone. Smith then starts off the substance of his dissenting opinion by acknowledging an undeniable fact, quote, the main winners from Judge Brown's opinion are George Soros and Gavin Newsom. The obvious losers are the people of Texas and the rule of law. Wow. Now remember who this man is. He's not just a federal judge. He's a towering figure. Judge Jerry Smith proceeds to totally dismantle the majority's decision and its unsubstantiated claim that race, not politics, was the driving factor in the redistricting. Throughout, he repeats the phrase, I dissent, more than a dozen times. Smith even includes 2 pages of a non-exhaustive list of misleading, deceptive, or false statements Judge Brown put forward, a very serious charge against a sitting judge. Smith says the list would be considerably longer, but for the press of time. Remember, he had to issue his opinion the next day. He said there's no lack of fodder, meaning there's no lack of evidence that this guy is a complete rogue judge. That is, the judge he's condemning, Judge Brown. Judge Smith apologizes for his dissent being disjointed, but says refining it was not possible because Brown and Guaderrama, quote, have not allowed it, unquote. Again, remember what they did. They issued their opinion without telling this judge, and so he had to quickly write his dissent the next day. Thus, his dissent, far from a literary masterpiece, but if it were a Nobel Prize for fiction, Judge Brown's opinion would be a prime candidate, he writes. Now, Judge Smith says Brown's opinion is so deceptive and so lacking in facts or law that Brown could have saved himself and the readers a lot of time and effort by merely stating the following. I just don't like what the legislature did here. It was unnecessary, and it seems unfair to disadvantage voters. I need to step in to make sure wiser heads prevail over the nakedly partisan and racially questionable actions of these zealous lawmakers. He's mocking the judge. I'm using my considerable clout as a federal district judge to put a stop to bad policy judgments. After all, I get paid to do what I think is right. Judge Brown's actions are, Judge Smith wrote in his dissent, the most blatant exercise of judicial activism that he has ever witnessed during his lengthy judicial career of nearly 40 years. Brown's actions are, Smith wrote, the most blatant exercise. According to Smith, the main question before the three-judge panel was, quote, whether the Texas legislature did its mid-decade congressional districting to gain political advantage or instead because the main goal of the Texas Republican legislators is to slash the voting rights of persons of color. Smith likened the approach of the lawyers and witnesses in this case to that of the Department of Justice lawyers from the Civil Rights Divisions of the prior Texas redistricting cases. He said it was obvious from the start the DOJ attorneys viewed state officials and the legislative majority and their staffs as a bunch of backwoods hayseed bigots who bemoaned the abolition of the poll tax and pined for the days of literacy tests and lynching. And the DOJ lawyers saw themselves as an expeditionary landing party arriving here just in time to rescue the state from oppression. He's talking about decades ago. And he's saying this case is no different. What's taken place here is an abomination. And Hans writes, having worked in the Civil Rights Division, I can assure you that this observation is absolutely 100% correct. While acknowledging that the Justice Department was not present in the case, Smith said that the same attitudes about Texas Republican legislators have been reflected in the testimony of multiple experts and witnesses presented by these plaintiffs, and occasionally by their talented counsel in the statements of the parties. But the obvious reason for the Texas redistricting, Smith wrote, was partisan gain, not racism. The majority, he wrote, commits grave error in concluding that the Texas legislature is more bigoted than political. And Judge Smith methodically points out all the grave errors Brown and Guaderrama made in evaluating the evidence in the case over what the legislators did and how and why the new districts were drawn and the way they were. Those errors are too numerous to list. Now remember, this poor judge had to do this in a 24-hour period. Judge Smith's conclusion, the majority committed grave errors, the key legal standard for overturning a preliminary order. Texas has already filed an appeal with the Supreme Court of the United States. Smith says the evidence in the case, as well as outside events like the, quote, victory lap in Houston to celebrate by California Governor Gavin Newsom, tell you all you need to know. This is about partisan politics, plain and simple. Regardless of one's political slant, he wrote, it's obvious what Texas is trying to do in 2025, obvious to everyone that is except the two judges who joined the majority opinion. The Republicans' national margin in the House of Representatives is so slim that squeezing out a majority might even depend day to day on whether some seats are vacant because of deaths or resignations. The new plan in Texas was to make more seats winnable for Republicans by moving some Democrat incumbents from their districts and rendering their districts unwinnable by Democrats. Smith described the plaintiff's theory, the one ultimately adopted by this rogue Judge Brown, as both perverse and bizarre. They claimed that if politics was the reason for redistricting, then the Republicans would not have drawn 5 new seats, but instead would have drawn 6, 7, or 8 additional seats, and that the reason they didn't is that the real reason for the redistricting was racial animus. The absurdity of that notion, he said, speaks for itself. Smith concludes his dissent by citing the unfairness the majority is imposing on Texas voters. He says, who are having a map implemented by their duly elected legislature overturned by a self-aggrandizing, results-oriented court. Man, he's ripping the skin off these two bastards. He tells the Supreme Court that Brown's order, replete with legal and factual error, accompanied by naked procedural abuse, demands reversal by the Supreme Court. And with this decision, Smith writes, darkness descends on the rule of law. Folks, I have a question for you. Do you believe America's best days are still ahead? With the 250th anniversary of the signing of the Declaration of Independence coming up in less than a year, my friends at the Heritage Foundation are taking stock of the current situation, and they need your input. They've launched a survey on America's future to gauge how Americans feel right now about where we are as a nation and where we're headed in the next 250 years. You know, for decades, your American values have been under attack, but now, with President Trump's administration in office, we have an opportunity to turn the tide and usher in a new golden age for America. But the Heritage Foundation needs to hear from you. What policies do patriots like you most care about? What do you believe are the defining principles of America? What legacy do you believe we should pass on to the next generation? Please visit heritage.org/Levin today and share your feedback and help shape the future of America. That's heritage.org/LEVIN. Paid for by the Heritage Foundation. These two judges, led by this guy Brown, they basically camouflage their opinions in the law. And yes, Brown was appointed by Trump. There's a lot of judges appointed by a lot of Republican presidents who flip once they're on the court, and this guy's obviously has flipped, absolutely has flipped. Doesn't matter who appointed him. Doesn't tell you anything about him. But what a disgrace. Absolute disgrace. Now let's see if the California system is upheld or not, which is a true outrage of the worst kind. Texas, you might say, did the same thing. No, they didn't. They didn't even come close to doing what California did. Or Massachusetts, where there's not a single Republican district. How does that work? How is that constitutional? And we could go on and on by why would we? The courts destroy themselves when they conduct themselves this way. And forever remember who this guy is. Judge Jeffrey Brown. A fake, a phony, a fraud. A kook lawyer dressed up as a judge. I'll be right back.